thank you very much for joining us. My name is Ian Scott, and I am the founder of Scott Legal. Today, we are going to talk about EB-5 investments and green card options and considerations. And what we're going to do, we're going to walk through the different options for EB-5, talk about the program itself a little bit, and then move on to exactly how it is that we apply for an EB-5 investment visa. Now, a few housekeeping items before we start. The firm was founded on an E2 visa some time ago, and we process primarily investor visas, and we also process a number of EB-5 visas, and we do them both in the space of regional centers, which we'll talk about a little bit. And we also do them in terms of direct investment EB-5, which we'll talk about as well. In terms of this webinar, after the webinar, we will turn this webinar into a recording, and we will post it online on our YouTube channel. So definitely feel free to subscribe to our YouTube channel, where we regularly post videos, and hit the notification button so that you are alerted when a new video is posted. The other thing we will send you is a copy of the PowerPoint presentation. So we will go through a PowerPoint presentation and send you a copy of that. And we also will send you a copy of the recording. And then finally, we have an EB-5 guide, and the guide walks through a lot of the things that we're going to talk about during this presentation. And it's just 20 or so page guide that has all of the requirements and describes the EB-5 program in more detail. So before we jump into the actual EB-5 program, I do want to spend a few minutes just talking about the different types of investor visas that are available. And the final housekeeping item is, if you do have questions throughout the presentation, do include those in the chat box. We will get to all questions, and we may not answer them right when you ask them, but we will come back at the end because there is time for questions we will go through those. So the different types of investor visas. So one type of investor visa is an E2 visa. And this is a visa where you have to invest a certain amount of money, no specific amount. It really depends on the business. And for this particular visa, there is no specific requirement with the number of jobs that you have to create. However, the whole point of that visa is to create employment in the US. So when we're looking at that visa and adjudicating that visa, or examiners adjudicating that visa, that really is what they're looking at. The next type of visa for investors in the US is something called the national interest waiver, and that's a green card. And we've been doing a number of these lately, where we move people from E2 that were on E2 to national interest waiver under the entrepreneur category. And this particular area, it's based on a case where you have to meet 3 prongs, and the prongs are listed here. But rather than spend time on this, I will refer you again to our YouTube channel or our future webinars, because we have entire webinars on national interest waivers. Similarly on E2, we have entire webinars on E2 visas and national interest waivers, where we speak for an hour about the actual requirements. And you can either sign up for a future webinar, or you can go to our YouTube channel and see some of our past webinars to get more information on that. The next type of investor visa is the International Entrepreneur Rule or Program, and this is a relatively newcomer to the field. It's not one that is very regularly processed, because people tend to move to one of the other types of visas just because of the newness of this. I think to date, probably only one has been approved. And what had happened here is it was a program that was introduced during the Obama administration, then the subsequent administration paused it, and then the Biden administration reactivated it. But I think it's still getting its legs a little bit, and I think it remains to be seen exactly how often that will be used. But again, we have whole webinars on the International Entrepreneur Rules. So I encourage you to go to the YouTube channel and or sign up for a future webinar. And then finally, we come to what we're going to speak about today, which is the EB-5 green card. So first, I just want to talk about the program overview and history, just to kind of give you a sense of what has happened over the last year or so. So this program's kind of, it's kind of gone up and down. Now, first and foremost, think of the program as having 2 components that are handled quite differently. So there's a regional center program, we'll talk about that a little bit, and then a direct investment program. So now a lot of the controversy there are two distinct things that happened. So one is that the entire program, so both regional center and direct investment, the investment amount during the last administration, the administration increased the investment amount from 500,000 to either 900,000, 500,000 and 1 million. They'll talk about those differences, to 900,000 and 1.8 million. But then someone sued them and said that the head of Department of Homeland Security didn't have the authority to do it, and a court agreed with them. So the amount went back to the 500,000 and the 1 million, right? So now that was for the entire program. Now, the other thing that happened over the last year was that for the regional center program, that particular program has to be reauthorized every period. Now, in an unprecedented event, it happened once before, but only for a very short period of time. The program last June, the regional center program last June, wasn't actually reauthorized, and it didn't get reauthorized until March 11th of 2022. So it went from June of 2021 to March 11th of 2022. And when they did reauthorize the program, the government did increase the investment amount, and they did it properly this time. So now the new investment, now there's a new investment amount for both regional centers and direct investment, and the regional center program is alive and well. And the purpose of this webinar is to go through the details of those two programs. So now let's talk about the differences between the regional center and the direct investment program. So the regional center program is one, give you an example. Let's say that Hyatt hotel chain wants to raise money to build a big hotel complex and wants to raise, say like $120 million. They may start an EB-5 program and get people that want a green card to invest, and then the Hyatt hotel would be the one that creates the jobs. And we're going to talk about what the specific requirements are, but the people who are interested in regional center are looking at, they're interested in a fairly passive investment. They don't really want to do much. The administration fees are quite high. So if you enter into one of these regional center programs, the administration fees are often in the $30,000, $40,000, $50,000 range with low return. In fact, when you factor in the administration fee, it's usually negative return. The projects, there is risk associated with the projects, like any investment. It's not a guarantee that if you give them $800,000 that you'll get that back with interest. Some regional centers have gone belly up and some have been subject to fraud. So it is a risk, just like any investment. The other thing with regional centers is that indirect jobs are counted, and what that means is that when we're looking at, you'll see when we go through the requirements that there's an investment component but also a job creation component. And with a regional center, what can happen is that the jobs that are created don't have to be direct. You can get an economist to write a report to say that, for example, in the hotel, because this hotel is being here, it's going to stimulate the local economy and create these indirect jobs. So that can be helpful as well to get to the job number that is required for the 10 full-time jobs per investment. The direct investment, is different. That's someone who wants control over the process. They're going to have their own business. They're going to be running their own business. Only direct jobs count, and the return is unlimited, right? Because it's your business, and if the business goes well, you can make any return. The project is not subject to reauthorization, so that's one. Even when the regional center program was inactive, the direct investment program was still alive and well. And interestingly enough, during the period when the amount was 500,000, that was the amount. It was 500,000 from the end of June right through to March 11th, and the government has affirmed that they're going to keep it that way. They're not going to challenge people who in fact invested the $500,000. And then the other thing with the direct investment is that some of the funds that let's say you had an E2 visa and you wanted to move now to a green card, some of the funds that you invested can actually count towards the investment. It's just generally speaking, this particular direct investment is for someone who wants control over the process. They're not interested in a passive investment. They really do want control over the process. So now let's delve into the EB-5 requirements themselves, and they are quite objective. This is a complex area. However, on the face of it, for what clients have to know, it is fairly objective. And that is that the client is investing $800,000 or $1,050,000 in a business, right? In what they call a new commercial enterprise. Now, this new commercial enterprise, the wording is new, but it's a business that started after even 1990. So that's it's something, a business that could have existed for a long time. So the reason there are two numbers is that the 800,000 would relate if the business was in what was called a targeted employment area. So that would be an area where the unemployment rate was 1.5 times the national average, or the area was defined as a rural area, so based on the population. So, and then if it wasn't, you would have to invest the higher investment amount. Now, in terms of which investment can be included, this can be different from E2. So for E2, in your investment amount, you can include legal fees, you can include other administrative fees. But for EB-5, there's specific regulations that deal with what can be included in an EB-5 investment, and not everything that was perhaps included in the E2 can be included. Similarly, when people are doing E2s and they want to convert to EB-5, the investment can be made over time. So we have one case that we're working on where the investment, at the time it was $500,000, but they invested about $100,000 a year for multiple years. And that's no problem. You just have to make sure and to make sure that the area was a TEA during all of those time periods to get the lower investment amount. One thing to keep in mind is if you do have an existing business and the existing business is, let's say just making a lot of money. Let's say you invested $100,000 and then the business, in a year made $1 million, and that sat and retained, and there was $500,000 in profit and that sat in retained earnings. That's not considered investment, right? That's like retained earnings is not investment. Investment is your personal investment that you have invested in the business. And they're very strict on this with EB-5. With E2, you can sometimes use an entity to be the investment vehicle, et cetera. For EB-5, you have to be the one that is personally investing. You can still get gifts and loans from people as long as they give you the money first, but you have to be the one personally investing. Just to give you an idea of how strict they can be with regional centers in particular, when a parent was gifting a child money and the parent gave the money directly to the regional center, even with the gift letter, USCIS was denying petitions saying that the child didn't personally invest because the money didn't go into their bank account first. So they can be quite strict. Another big difference between E2 and EB-5 is source of funds. So when we're doing an E2 application, even though the source of funds requirement is similar, we pretty much gloss over it. We pretty much gloss over it during the during the process. We pretty much gloss over it. So the but with EB-5, there is a very, very, very strict requirement that you document where the money came from, and they really, really do take that to the nth degree. So in terms of someone who's asked a question whether you can use the profit from a business to invest further, yeah, you absolutely can, as long as that money was paid out to you, paid out to your personal account, you pay taxes on it, and then you reinvested the money in the business. But that trail would have to be documented, and if it wasn't documented well, then you could definitely run into difficulties. The investment has to be an equity investment, so it's not like you can just say, okay, I'm going to loan a business $800,000. You have to take back something, whether it's a limited partnership unit, et cetera. Another difference from E2 is that E2 does require that the investor own at least 50%. EB-5 doesn't. You can own 1% or even less than 1%. In terms of the second piece of EB-5 is creation of jobs. So for each green card for the investor, you have to create 10 full-time jobs. And now these jobs are not like E2 jobs. They're full-time jobs, not part-time, full-time jobs. And they're jobs that are for US citizens or green card holders. That's, not the case with E2 at all. But and we talked a little bit about the direct versus indirect investment. EB-5, when you're doing a direct investment, requires a detailed business plan similar to E2, but just I'd say more detailed. So there's a famous case called Matter of Ho that deals with the business plan requirement for EB-5. And then the money. One important thing with EB-5 is the money has to be linked to job creation. So let's say that you are investing in a business that had 10 full-time employees and the employees were already there, and then you invested $800,000 in that business, you'd still have to create 10 new jobs because the 800,000 that you invested doesn't have anything to do with the jobs that were already created. So generally speaking, the money that you invest has to be linked to the jobs. And then it is quite an extensive process to document the full-time positions and that they're actually qualified workers, because they are quite strict about that. When you're filing an EB-5 petition, you file an I-526 petition. And one big change that happened in March 11th was that you're now permitted to file an I-485 and I-526 petition concurrently, which is great because if people are in the United States, then they can file those petitions and stay in the United States based on that. Because before, the filing of the I-526 petition didn't really give you any benefit until it was approved. But now, especially given there are waits that are years in length, so I-526 petitions are taking 2, 3, sometimes 4 years to be approved. So you can file the I-485 petition. And then after you have the green card, 2 years after you have the green card, you have to file what's called an I-829 petition to remove the conditions. And what that means is that the removing the conditions just means that you have shown the government that you actually have created the 10 full-time jobs. So we talked at the beginning about the changes to the program. So one of the things they had to do when they made these changes on March 11th was they had to really restore confidence in the program, because people really were upset, right? They were invested, they were in limbo, they had invested, they were in limbo with respect to the program. So they reauthorized it for much longer than they normally do. So it's reauthorized until September 30th, 2027. So new filings in 60 days. So this was a while ago, so that actually might be coming up to that date. But they're also kind of, to give people more comfort, is that anything filed before September 30th will be adjudicated. So because what was happening this time was that people that had petitions pending, because the program had stopped, they just stopped adjudicating their petitions. So now they're kind of giving people comfort: as long as you file your petition before September 30th, 2026, we won't stop adjudicating, it will continue, which is good. We talked about the increases in amounts of the investment amount. The other big change they made was they changed the rules for what designates a TA, and said that the government is solely responsible for designating this. And the reason was because there were some tricks people played to be able to designate something as a TA, even when it wasn't an area that was subject to high unemployment. Like we, have a client that has a business in Soho, in Manhattan, which is one of the maybe richest areas in the country. But in the past, you were able to link census tracts through areas that had higher unemployment to come up with a number that was 1.5 times the national average, and that was all legal. So they eliminated some of those loopholes, and then they set aside specific numbers for different groups, which are on the slide. The other thing they clarified was that if you filed your application before June 30th, 2021 with a lower investment amount, that's no problem. They will still adjudicate it, because there was a question as to whether that would happen. And then we talked about the filing the I-485 concurrently, and that is great because the person, if they're in the US, they can file for work authorization and travel authorization. And then the other change is that before, the source of funds analysis really only had to go to adjudicating the investment, like the 500,000 or 800,000. But now you actually have to show source of funds for the amount you pay for administrative fees. So if you do a regional center, and you have to pay another 50,000, and your legal fees, you have to show source of funds for all of that. And then they clarified that loans and gifts can come from anybody. And then they gave some relief as well to, like, if your regional center fails, you're not like out of luck. So generally speaking, the changes were positive. Positive. They could have gone further, but the changes were positive. A few other things to consider with EB-5. The investment does have to be at risk. So you can't just say, okay, I'm going to invest $800,000 and put it in a business bank account. You actually have to have contracts and have spent the money. With loans and gifts, because EB-5 takes so long to adjudicate, if you get a gift from a relative, you better make sure that they're paying gift tax in their country, because when the petition comes time to be adjudicated, USCIS will raise that. One other interesting thing with EB-5 investment is that EB-5 E2, if you, let's say that someone wanted to buy a restaurant and they spent $200,000 and they did that with E2, that would be no problem. For EB-5, that's a problem because the money's not going to create jobs, it's going to the seller. So you can't just have a business purchase and say, okay, I'm buying a business for $800,000, give me an EB-5. The money has to be, goes back again to the money has to be directly linked to job creation. And they say if the money is going to the seller, that's not directly linked. It would have to be invested in the business and then create jobs. Again, we talked about how much you have to own. It's no specific amount. And with regional centers or any EB-5 investment, you can't have a guaranteed return in investment. And we talked about already kind of moving, moving from EB-5 we talked about already about moving from EB-5. So there's an example here. I'm not going to run through it. It's definitely very specific to direct. Very specific to direct investments, the other considerations, kind of timing considerations that we have, EB-5 petitions take a long time to be adjudicated. So they take, 4 years, 3-4 years for the I-526 petition to be adjudicated. And then in some cases, because there are only 10,000 EB-5 visas each year that are issued, in some cases, there's country-specific quotas, and once you let's say all the visas for China have already been issued, then there would be like a wait for new people who wanted the visa from China. And definitely, if you apply for an EB-5, then what you have to do is, if you have a visa already in the US, you have to kind of make sure that you are, the dates on your visa are going to allow you to stay in the US, the time that you want to, because if you file this petition and you want to renew other non-immigrant petitions like E2 or TN or other non-immigrant petitions, they may raise dual intent issues saying that you're applying for a green card. Often people will apply for multiple green cards at the same time. We have someone that was just approved for direct investment EB-5, and she is also applying for national interest waiver, but the national interest waiver would actually be better for her because she doesn't have to then remove the conditions in a few years. But so that's something we're looking at, and planning is really key. And planning is really key with respect to all of this. So we do have another question. Does investment count buying business property as well, or the cost to run the business only? Does investment count buying business property as well? Or so I think I understand the question, but if so the example that I used was that if someone buys a business, then that can't count, that they can't get an EB-5. So let's say someone buys a restaurant and buys the shares and then gives the seller the money, that doesn't count. But similarly, if they just bought the assets of that exact same business and then started that same business again, that wouldn't count either. That's just a different form of the same transaction. So in substance, it's the same. But if you bought business assets of the business and then started a new business that was different, or you could argue that was different, then that could be something that that could be something that you look at, something that you look at for EB-5. Perfect. So I don't see any other questions. So I'm just going to run back to the example to go through it briefly, just to illustrate a few of the points that we talked about. So, in this example, someone's on an Me2 and they purchased a business for $300,000. The business had 5 full-time employees, and she paid lawyers $40,000 in fees to do the E2. That's high for an E2, but that's what she paid. At the end of 2019, she took another $200,000 that was a gift. And now for the purposes of this example, because I see now that this is an old example, this is when the investment amount was $500,000. So for the purposes of this example, just assume it's $500,000. When the money was invested, the $200,000, right? She had 10 full-time employees working at the company. So she hired 5 more, right? So at the end of 2019, she also paid herself a $100,000 bonus after the company made $1 million, right? So on January 1st, 2020, she applied for the EB-5, saying that she's invested $1.5 million at 300 plus the 200 plus the 1 million that the company made. And she says that she's also created 10 full-time jobs, so she's eligible, right? And she plans to hire 3 or 4 more people, but is not committed to this. So let's go through the issues with this. So Helen, the E2, if she purchased a business for $300,000, as I said, that doesn't count for EB-5. That's perfectly fine for E2, but doesn't count for EB-5 because she gave the money to the seller. It doesn't count. Similarly, for EB-5, the 5 full-time employees that are there when she bought the business don't count either, because she can buy the business and pay the person $300,000, and she can still use this as EB-5, but she would have to invest another $500,000 in this example, because we're saying the amount that needs to be invested is $500,000. The other kind of thing to keep in mind is the $40,000 can count for substantive investment in E2, but not for EB-5. Then, because it's an administrative fee, a legal fee, you still have to prove the source of funds for it, but it's not part of the $800,000 that you would have to invest. So now she took another $200,000 that was gifted to her, and and that, like, the only reason this is in the example is because 2 reasons. One is that it doesn't matter that it comes through inheritance and the person has died, and they don't care. You have to go back and get documents from 15, 20, 30 years ago to prove where that money came from. And also it could be a problem that the money was deposited directly in the business bank account, rather than giving it to Helen first. So that's another EB-5 problem that could be an issue. So she and when we get to the employees, she says, oh, I have 10 full-time employees. Well, she doesn't. She has 5. If she invested $200,000 and we can prove the source of funds, then she has another 300,000 if it was 500,000, or more if it was 800,000 to go to invest. The other thing to keep in mind is she paid herself a bonus of $100,000. So the government will say that if she invested $200,000, then $100,000 of that was money that she paid back to herself. So now she's back down to only investing $100,000. So, these are all things I think that come up. They really do come up when you're looking at EB-5, and I think it's definitely important to work with an experienced immigration lawyer when you look at this. Okay, so we do have a few more questions here. So if I get dual citizenship from India, will this affect my EB-5? No. So EB-5, the quotas, I imagine that's what they're talking about. Whoever wrote this, they deal with country of birth. So you're assigned. If, let's say, there was a delay in a particular visa category, it's based on your country of birth. So getting a new nationality doesn't make any difference. Florida is an ETA or regional for, I think you mean TEA. So I think the question is Florida a targeted employment area or regional for, I don't really fully understand the question, but I'll just explain what the terms mean. So TEA means an area where, based on the census tract, the area is an area where the unemployment rate is 1.5 times the national average. So there's data that you can go to that looks at that particular area. So it's not state specific, it's like, specific to that particular census tract. It's 1.5 times the national average. Every state has regional center projects, right? So if the state has a regional center project, normally the regional center projects meet the TEA requirements because they're only asking for the $800,000. So, you just make sure that your immigration lawyer that looks at it is comfortable that the particular state meets the actual requirement. Perfect. So I think that's it for questions. So we'll stop there. A few things. Again, what we will do is we will send out a copy of this presentation. We'll send out a video of the webinar that you'll have. That we'll post it on our YouTube channel as well, and we'll send you the guide. And again, feel free to subscribe to our YouTube channel because we will continue to make videos. Perfect. Now, thank you all very much for joining.